effectively, what the Chamber's approach is this. Fair trial rights, broadly speaking, may be provided for in the written laws of Rwanda. There may be evidence that these laws are not applied in practice. And indeed, some of the laws themselves do appear to violate an accused person's fair trial rights anyway. But, the referral chamber says, but we're going to give the Rwandan courts a chance of proving themselves. We're going to give the Rwandan courts a chance of demonstrating that a fair trial can take place. Now again, going back to what Rule 11 bis says, what the test is, that is, I think, a complete misapplication of the test. It's a gross misapplication of the test. But what the referral chamber effectively says is this: if it all goes horribly wrong on the ground, we will have monitors on the ground to tell us that it's all going horribly wrong, and then, if we see fit, we can revoke the referral. What the referral chamber also says is that revocation would, in any event, be a final straw sort of remedy. Of course, we're talking here about ICTR transfers. In the case of extradition from third countries, the safety net of monitoring and revocation doesn't exist at all. This brings me on to the second feature that I think is important of the decision in Uwinkindi, and it is the monitoring and revocation mechanisms themselves and how they work. The OTP described these mechanisms as providing additional oversight for ensuring fair trial rights of an accused. The rules of the tribunal provided intended that these mechanisms would be a safety net, as it were, to protect the accused from receiving an unfair trial. But in the Uwinkindi decision, the referral chamber really doesn't accord the monitoring and revocation mechanisms the function of a safety net. Rather, it makes these mechanisms the very foundation of the fair trial guarantees. What I mean by this is that the whole basis of the decision, from beginning to end, the decision to refer the accused to Rwanda, is based on the existence of these mechanisms and on the presumed proper functioning of these mechanisms. And the way in which we described this approach by the referral chamber in our appeal, this terrible, fundamental, and very dangerous fudge, was we described it as a wait and see approach. Time precludes me from going on about the various ups and downs that, in terms of what has happened with regard to these mechanisms since the Appeals Chamber upheld its decision. But in brief, the African Commission on People, 5 minutes, thank you, Human and People's Rights assigned to monitor the trial, they're not even on the ground yet. Instead, the tribunal assigned 2 legal officers to monitor the pre-trial stage on an interim basis. And one of these officers has already been replaced by another officer by the president of the tribunal for reasons which are very opaque indeed. The third feature of the availability, the third feature of the decision is the availability and protection of defense witnesses in Rwanda, and this is really fundamental. Again, the prosecutor relied on various reforms in Rwandan law, particularly in relation to the existence of a witness or witness protection programs, or better witness protection programs than had existed, to argue that defense witnesses would be safe and could give evidence under the same conditions as the prosecution witnesses could. It was acknowledged by the referral chamber that historically the vast majority, and we will know this from our own experience, the vast majority of potential defense witnesses live outside of Rwanda. But what the prosecutor and what ultimately the referral chamber chose to ignore is that whilst the current regime in Rwanda is in power, there is practically nothing that can be said by the Rwandan authorities that would be believed by members of the Rwandan diaspora in terms of guarantees of their safety were they to give evidence for the defence. No amount of guarantees or assurances of safety would be accepted at face value. And in making that argument, we didn't just rely on anecdotal hearsay. This was concrete information that we were able to gather from no less than 49 potential defence witnesses who said in terms they would, whilst they would be prepared to give evidence before the ICTR in defence of Jean Uwinkindi were he to be tried in Arusha, under no circumstances would they give evidence for the defence if the trial were to take place in Rwanda. I'll finish on this point by saying that whilst it may be tempting to put this refusal, this position on the part of potential Rwandan defence witnesses, put it down to slightly hysterical paranoia on the part of Rwandans living in exile who've been fed a daily diet of horror stories about how unevil and untrustworthy the RPF regime is or whatever. Well, that's until you consider the statement made by the Minister of Justice, who, in a discussion before the Rwandan Senate in 2007, relating to the granting of immunity to defence witnesses coming to Rwanda, he said this: "We have nothing to lose by granting immunity. If anything, we have everything to gain by these people turning up. It will be a step forward toward their being captured. They will sign affidavits on which their current address will be shown, and that would at any other time lead to their arrest." Tarsis Karugarama, who is the current Minister of Justice, and that statement has never been denied by him. You can understand how such a statement spreads like wildfire throughout the Rwandan diaspora. In short, Rwandans don't trust their government. Rwandans, certainly in the diaspora, don't trust their government or the promises senior ministers make. Time has caught me out, I think.
Merci beaucoup.